5 seconds to go. Start. The accused had conspired or attempted to commit a terrorist act or committed any act preparatory to the commission of a terrorist act. Such material evidence would be sufficient to invoke Section 18. For attracting Section 18, the involvement of the accused in the actual commission of terrorist act as defined in Section 15 need not be shown. The High Court, having miserably failed to comprehend the correct import of Section 18, read with the definition of Terrorist Act as contemplated in Section 15 of UPA. In our opinion, the High Court has fallen into a patent and manifest error, though it was sought to be submitted by learned counsel appearing for the respondents that the material evidence collected by the investigating agency and statements of witnesses relied upon by the prosecuting agency is not reliable, the said submission cannot be accepted. As held by this court in Vatali's case, the question of discarding the material or document at the stage of considering the bail application of an accused on the ground of being not reliable or inadmissible in evidence is not permissible. The court must look at the contents of the documents and take such documents into account as it is and satisfy itself on the basis of broad probabilities regarding the involvement of the accused in the commission of the alleged offences for recording whether a prima facie case is made out against the accused. No doubt, in Union of India versus K.A. Najib, relied upon by the learned counsels for the respondents, it has been observed that a constitutional court is not strictly bound by the prohibitory provisions of grant of bail in 1967 Act and can exercise its constitutional jurisdiction to release the accused on bail who has been incarcerated for a long period of time relying upon Article 21 of the Constitution of India. The said observations may not be applicable to the facts of the present case. In the said case, this court did not interfere with the order passed by the High Court granting bail to the accused in the said case on the ground that the said accused had already spent 5 years and 5 months in custody and the trial was likely to take long time. So far as the respondents in the instant appeals are concerned, they are in custody hardly for 1.5 years, apart from the fact that all the respondents are shown to have been involved in previous cases. There are about 8 to 9 previous cases shown in the charge sheet against the respondents except accused number 1, 4 and 6 who are shown to have been involved in 2 cases. Considering the nature and gravity of the alleged offences and considering their criminal antecedents, in our opinion, High Court should not have taken a lenient view, more particularly when there was sufficient material to show their prima facie involvement in the alleged offences under the UPA. Similarly, the decision in Vernon versus State of Maharashtra and another relied upon by the learned counsels for the respondents also would be of hardly any help inasmuch in the said case this court, after considering allegations made against the accused and long incarnation of 5 years, did not think it proper to continue further detention of the appellant's accused in the said case. In Shoma Kanti Sen versus State of Maharashtra and another, relied upon by the learned counsels for the respondents, this court had deemed it proper to release the accused involved in the offences under the UPA on bail, having considered the facts of the case and observing that Section 43(d)(5) of UPA was not applicable. Stop.